On this morning's Ag Issues program, as always, a pleasure to bring on to the program Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, as he joins us on the program this morning. Roger, good morning. How are you?
Good morning, Greg. Just fine.
Well, let's get to it, and I'll make an obvious statement and ask you an obvious question. Is it an understatement to say that tax issues never a dull moment as far as if they get to courts on what is discussed?
Well, they're not, but I'm going to pull a switcheroo on you this morning. I apologize for this. I sent you the wrong article on Friday to discuss. And in looking at those tax topics I sent you, while they are pretty important to agriculture and of interest, I'm not sure they're of interest to a farm audience at 6 in the morning. So I did email you when I saw this just a few moments ago and said, just roll with it, just flow with it this morning. But
okay.
We've got a bunch of other topics that I think this audience would find more interesting than those detailed, intensive tax topics. If you can find, I don't know if you have access to that.
Yes, I do. Yes, I do. As a matter of fact.
Okay, I'll just take off into this, and you can catch up as you get into it. So I apologize for that. That's the first time that's ever happened to me, and I think in about 27 or 28 years that I sent the wrong file. I think one of the things that says is I've got too much on my plate right now.
Okay.
Last week, of course, was finishing up grading law school exams. When you have 38 students and they all write essays for the exams, plus an undergraduate class that was wrapping up at the same time, plus my normal stuff and getting ready to speak to the Idaho Bar Association this week and the Kansas Society of CPAs, and then getting ready for Oregon that's coming up and Wisconsin that's coming up. It's a bit busy, so I apologize for grabbing the wrong file for you this morning. But the first one I'd like to talk about, Greg, is an interesting case out of a federal district court in the Northern District of Indiana. And this is an issue, it's kind of a unique issue, but I think we can see how this could come up. And what happened was that you had Tyson Fresh Meats, which is the processing plant that is the plaintiff in this case, and they said, look, we bought hogs from this farm, and this farm subcontracted with another party to raise the hogs. So it's a contract hog production arrangement. And what is delivered is 267 hogs to the processing plant. They process the hogs, commingle the meat with other meat at the plant. Well, 2 days later, the farm tells Tyson that the hogs hadn't gone through the required withdrawal period for a certain supplement. Well, that trips the federal law. FDA gets involved in all these types of things, some state law issues too. But the end result was Tyson had to dispose of more than 1.7 million pounds of now what's determined to be contaminated fresh meat. And so they sued the farm for negligence and breach of Indiana product liability law. And the farm claimed that we're providing you a service, not a product, and therefore the hogs are not a product subject to state product liability law, which is one of the things that Tyson was suing based on. And so they said, well, you can't sue us based on product liability law because we provide a service for you. We're raising your hog. You own the hog. It's under a contract production arrangement. We're just providing a service. You can't sue us for product liability. And Tyson moved to dismiss the case that the court said that, well, that's an argument that we're going to have a jury decide. And so that service product distinction is a big issue. The jury trial appeals that, and the Indiana Court of Appeals said that goods under the Indiana product liability law covers all things that are movable when they're contracted for, and that includes the unborn young of animals as well as adult animals. And so the product liability claim goes through. They can sue based on that farm based on product liability. Now, on the next appellate court said that Tyson had failed to allege enough facts to indicate that they owed Tyson a duty of care, and so they couldn't proceed on the negligence claim. But it's an interesting case as to whether product liability law would apply to be used against a farm when you're raising livestock, in this instance hogs, under a production contract.
Roger, let's go on here. And one of the things that we hear about in the news is concerning hog operation permits. Let's stick with the hog theme, so to speak. But this is one that involves a recent decision on a Kansas case concerning the challenge to hog operation permits.
Yeah, we often see this in the country, not just in Kansas, have certain type of either activist groups, anti-ag groups, anti-confinement animal livestock operations, or environmental groups. And this one had to be the Sierra Club that will confinement hog operations on the basis that they shouldn't have been granted a permit, either by the state or by a county, whatever the rules are in the particular jurisdiction. A lot of times what those cases come down to, do you even have the ability to bring a case in court? Have you suffered some type of discernible injury? Well, if you have a member in the area that is directly affected, then the organization can sue on behalf of its member. Here, the Sierra Club couldn't establish that they had sufficient requisites for standing, and so they couldn't petition the court for the court to review the permits. And even though the trial court said they could, the appellate court in Kansas last month said, no, there's not enough standing here. And so they sent the case back to the trial court to dismiss the Sierra Club's challenge and reinstate the original permits. And so it's just another one of those things that farming operations have to be aware of. You could possibly get sued by groups that don't want you to have, or people that don't want you to have permits. And often, again, the issue comes down to, well, can they do that? Do they have standing to sue? And here's one case where the court said no, they did not.
Another case as well, and people have heard, and you and I talk about the ag-gag laws, being able to take videos or take pictures of facilities as well. And of course, this is one that involved the Kansas case that involves the potential of secret filming taking place.
Yeah, this is the so-called Kansas law. Kansas had the first statute in the country on this type of a law, and it was enacted over 30 years ago. And it was struck down by the Kansas courts as unconstitutional, and the Attorney General in Kansas petitioned the U.S. Supreme Court to take the case, and the U.S. Supreme Court just a few days ago said, no, we're not going to hear the case. Now, that doesn't really mean this issue is over. There is another case that's out there, actually two of them, one in the 8th Circuit and one in the 9th Circuit. The 9th Circuit involves the Idaho law. The 8th Circuit involves the Iowa law. And they're a little bit different than the result that the 10th Circuit reached on the Kansas case. So I don't see this as the Supreme Court saying we're not interested, 100% not interested in this issue. They may have thought that this wasn't the best case on this particular issue for them to take. Because there is, as I mentioned, there is a distinguishing point made between the 8th Circuit and the 9th Circuit. So, one of those cases may end up in the lap of the U.S. Supreme Court that they would take. This is one of the things I'll talk about later this week with the Idaho bar. I'm talking real estate with them, in agriculture, real estate related issues with respect to agriculture, and we're going to talk about what's going on with the Idaho statute. So this ag-gag issue, it's a tough issue for farmers and ranchers, and I do mention in my longer blog article devoted just to that particular topic that there may be a constitutional way to protect livestock facilities from people that basically lie to get hired so that they can get inside, take these clandestine videos, and then put them, doctor them up a little bit, make it more inflammatory, and put them on social media, and get all types of problems created for these operations. Of course, we never want to treat animals inhumanely, but there's a whole segment of the population, as you well know, Greg, that has no understanding of what goes on a farm or a ranch, let alone a processing facility, and it looks bad to them. Well, that's where your food comes from, and that's how your food is processed. And so it's a rough issue for agriculture. It's a tough issue for legislators that are trying to provide protection from outside attacks like this. But then you've got the constitutional concerns and the free speech concerns, and it gets tied up in the courts, and it is a tough issue, and I don't think it's done. But here, the U.S. Supreme Court said we're not going to hear that case from Kansas.
And I think we've discussed this before. Is it how it's worded by these states as to how to enact the law or how to get a law like that maybe change the wording around or change the intent of the wording around? I mean, not radically change it, but tweak it somewhat.
Yeah, and I think I've written in a previous post a couple months ago that I think the Indiana statute might be the best approach that's out there, and they basically have taken the free speech issue out of it, and they said, okay, you can be on our premises, you have a license to be here for a specific purpose. Once you stray from that purpose, we have the ability to remove you from the premises because we were only granting you permission to be here for a particular reason. And that removes the speech and the content issue out of it and just says, okay, you can be here for purpose X, not purpose Y. You do purpose Y, you're gone. That's an interesting approach. Now, we haven't had litigation on the Indiana statute, but I think that totally removes the speech issue out of it. And we get away from whether your speech is content-based or whether I have a right to film these things because the license says you can't do these things up front and before you even get on the premises, and a private party has the right to do that. So if we're carefully confining the reason that a person is on the premises for business, then the notion is if you get beyond those parameters, then the licensor has the ability to remove you as the licensee. Now, that's an interesting approach, and that may have more merit to it.
Roger McEowen, professor of agricultural law and taxation at the Washburn University School of Law, is joining us. And Roger, let's go down to a recent decision on a court case in Texas. This has to do, or the subject of prior occupancy of a home not being required for exclusion under Medicaid rules.
Yeah, this is now it is specific to Texas, but I think we can learn some things from this one. It is interesting to pay attention to it. This is the Texas Court of Appeals. What this is a case involving the Medicaid rules, as you indicated here. And, of course, under those rules, as many people know, a person cannot receive Medicaid benefits. Of course, that's what pays for long-term care in a nursing home if you have too many resources, too many assets, too much income. And so you basically have to deplete your income and your assets paying for your long-term care before Medicaid benefits kicks in. Okay. With that much said, there still are assets that are exempt from that eligibility calculation. One of the big ones would be the home that you're going to return to, or the homestead. If it's a farming operation and it continues to be a farming operation, say by the spouse that's not in the nursing home, known as the community spouse, then that's also exempt. And that's a pretty important point. And so a lot of planning involves around trying to protect the home. If you have a spouse that's not in the nursing home and one spouse that is, we don't want to have that value of the equity value in that home or equity value of a farm count towards your eligibility purposes for Medicaid and make the spouse that's in the nursing home ineligible. An interesting thing happened in this Texas case. Both mom and dad ended up in the nursing home and were trying to exclude the home's value, their equity value in the home. What they did was they bought a home back in 1974 and they lived there until late in 2010. They sold it to their daughter. They moved into a rental property that the daughter owned. In early 2017, they entered a nursing home and then after they entered the nursing home, keep in mind, they bought a 1/2 interest in their original home that they had sold to the daughter. And the purpose the stated purpose for doing so was to secure equity in a home that they could return to if one or both of them should be able to leave the nursing home, end quote. This is really, it's either desperate or clever planning by the attorneys that did this for them. because what they're angling for here is a provision in Medicaid that says, well, you can exclude the equity value of the home if you have an intent to return to the home. Now, the issue became in this case because the state Medicaid agency in Texas said, no, you cannot exclude that because you did not own the home. You did not have that interest in the home at the time you went into the nursing home and made your application for Medicaid benefits. So therefore, how could you have a home to return to at the time, because at the time you entered the nursing home and filled out your application, you didn't own a home? And the court said, that's not what the key is here. The key is, do they have the subjective intent to return to a home? It doesn't matter whether they own the interest in the home or a home outright at the time they filled out their application for benefits. So the court said, yes, based on the overlapping federal and state rules that apply to Medicaid, the way they read the language was to say, as long as you have an interest in a home that you want to return to, the equity value of that is not included in your Medicaid eligibility computation. I think that's pretty important, and we can make application of that in the ag sector too, if we want to exclude the value of an interest in some farm property or a homestead on a farm. And we do it after the fact, after the party has entered the nursing home and made an application for benefits. Interesting case. I would caution again, it's not a federal court decision. It's a Texas Court of Appeals decision. But that's the first time I've seen a court construe that like that, outright like that. There have been some nibbles on the edges, particularly out of Arkansas in prior cases, but not as blatant as this one. So an interesting development on Medicaid planning out of Texas.
Maybe this is my naivete, being naive here, Roger, would there be different laws in different states, or just this has not come up in this type of situation?
Yeah, that's a good question. Medicaid is an interrelated federal-state program. There are federal rules, and then each state has its own rules that can either match the federal rules or they can change it a little bit and modify it a bit in their particular state. So this one is unique to the Texas provisions, but I would say in this instance, the Texas Court of Appeals was largely construing the federal regulation involving intent to return to a home and the timing of that. And here the Texas court said, well, you can have the intent at some point in time to return to the home, and it doesn't matter if you owned the home at the time you applied for benefits. Interesting. Now, I would say we don't want to get clients into that position where we have to be that clever in making those arguments after the fact. We want to do our planning up front for eventual need for long-term health care, whether that's long-term care insurance, whether that's transferring of assets adequately before we get into a nursing home. We want to try to avoid these situations and stay out of court on this and not hope that we luck out and get a win like this. So I would caution people like that, but on that point. But this is an interesting opinion, and we'll see if this catches on, if this interpretation catches on elsewhere.
All right, Roger, if people want to know more about some of the things we discussed, this is up in your blog?
Yes, this was an article talked about today. It was an article I posted on May 4, and that's accessible through my homepage of my website, and that's washburnlaw.edu/Walter, WALTR, and then the blog can be accessed down the left-hand side.
All right, sounds good. Roger, as always, appreciated. Thank you very much.
Thanks for being a good sport for allowing on you at the last moment this morning.
No, hey, that's all right. That's all right. Roger McEowen, Professor of Agricultural Law and Taxation at the Washburn University School of Law, joins us on the Ag Issues program here on 580 WIBW.